at the same time, there's another form called N-600K. So this is a major issue that's coming out of Egypt, where we have people that are U.S. citizens. Most of the time, they're born in the United States and then left and went to their home country, in Egypt in particular. And later on, they had kids, and they applied for their kids' citizenship through getting them a green card. And then once the green card is issued, they fly to the United States. And the regulations say you have to come and reside with the U.S. citizen parent with that as a green card holder, and then you obtain citizenship. Kind of this mystical, magic way you get citizenship. But they never define what residing is per se, what exactly that means. So a lot of these families applied for the I-130, did consular processing, came to the United States, and then filed for a passport. The Department of State issued the passport, and then they went back to Egypt. And they had green cards for the citizenship for the kids. And when you're a child, you have to renew every 5 years. So they renewed it when they're 5 or 6, and they renewed it again when they're 10. And now in 2022, when they're 15 or so, they're going to the embassy, and the embassy is asking in Cairo, saying, "Hey, when you got the green card and then entered the United States, how long did you stay in the United States?" And almost all these families, they say, like, "Oh, we went there for a week or two, got the passport, came back." And the embassy is denying and revoking all these passports for hundreds of young people, saying that you didn't reside with the U.S. citizen parent in the United States, so you didn't satisfy the requirement for obtaining citizenship, and they're revoking these. And this is, I mean, it's almost like a disease diagnosis for these families. It's really tragic. They thought the child's a U.S. citizen. They have this backup to be able to leave the United States when needed, and they don't have that. I got involved one family, it's left another, and there's dozens and hundreds of these cases. I'm talking with a dozen of them myself. So that's interesting. And the solution for a lot of them is going to be filing another I-130 and then moving to the United States and residing here. I told them, hey, listen, get the green card, come to the United States, have the child go to school here for a semester. So they're going to school, they're residing here, they have evidence that you're the parent residing with them with school records. And just do it for a semester. That takes care of residing. There's no definition for residing is. And these people have been asking the embassy, well, what do you mean by the residing? They're like, I don't know. Sometimes they'll say 3 months. Sometimes they'll say there's no definition. I think going to school for at least a semester is strong enough. And it's like not only file for the passport, but also file for Form N-600 to get a certificate of citizenship. That's that. But there's this other exception kind of case that's called the N-600K. And wrap your head around how the N-600, N-600K, and 565 and all this stuff works kind of confusing. It took me a little bit. But the N-600K is this thing where you get citizenship if the child is going to continue living abroad. So you have to continue living abroad, the opposite of the other version. You have to be residing. And it's if your parent, was in the United States for 5 years, blah, blah, which a lot of these cases, the parents were born in the United States, left and never came back to live here. But it has this other exception that says if your grandparent lived in the United States for 5 years and is a citizen, like the parent that's a citizen, their parent's a citizen, you can get it. So let me back it up. So we have cases where the child is going to get citizenship because they're living abroad with the U.S. citizen parent. The U.S. citizen parent didn't live in the United States for 5 years, so they can't use their physical presence in the U.S., but the grandparent did. And it's not required that the grandparent have that time in the United States while they're a citizen. It could be beforehand. So we have a case, for example, where the grandparent lived in the United States in the 60s and 70s, and then, went to overseas, had a child. As soon as the child was born in the United States, became a citizen, they left and lived overseas and haven't been back. Luckily, they kept documentation of the 60s and 70s and have good documentation. And we submit that for Form N-600K, show that the child is living abroad with a U.S. citizen parent, and that they intend to live abroad. So they have school, they have house there, and the parents are working. And then we submit that to USCIS. And, I have one case in Texas where as soon as we submitted it, a week later, we got an email from and saying, we're ready to go. We're going to schedule you. I'm like, oh, this is great. And then I filed another case in Southern California, and we got a receipt, and nothing's moving yet. So the timelines, as always, on USCIS.gov are completely inconsistent as to what the actual situation is. And each office is different. But that was incredible. I was really happy about that Texas case. I'm like, oh, this is easy. And then another family did in Southern California. Now I'm like, I should just send everyone to Texas. It might cost more for them to get a hotel and to live with family or something like that. But that was really smooth how that's happening. So that's just part of the inconsistency. But it's a very interesting kind of case, this N-600K, to know about.